published on the authority of the House, can be found on the Parliament website. Honourable Simeon Brown.
I move that the Offshore Renewable Energy Bill be now read for a first time. I nominate the Transport and Infrastructure Committee to consider the bill. Mr Speaker, this bill delivers on a commitment to put a regulatory regime in place for offshore renewable energy as part of the government's Electrify New Zealand plan. Offshore wind is the most developed offshore renewable energy technology, and New Zealand has world-class offshore wind resources with some of the highest capacity factors in the world. New Zealand currently does not have a regulatory regime for offshore renewable energy, and this bill delivers that regulatory regime so we can unlock the potential that offshore renewable energy has for New Zealand. This bill establishes new permitting regimes for all forms of offshore renewable energy, including wind, wave and tidal. The permitting regime aims to provide greater certainty to potential developers to invest in offshore renewable energy developments and allows the selection of developments that best meet New Zealand's interests. The bill also provides for the management of risks to the Crown and the public. Establishing a regime is an important step that will give investors the confidence to construct generation assets to help power New Zealand's increasing electrified economy. This bill will help us do that. This bill introduces two dedicated offshore renewable energy permits. First, feasibility permits, which will give developers greater certainty to undertake feasibility studies in specified areas. It will give the holder the right to apply for relevant resource or marine consents in that area, and the exclusive ability to apply for a commercial permit to build and operate offshore renewable energy infrastructure in that area. Secondly, it allows for commercial permits. A commercial permit must be obtained before construction begins and provides assurance that the project is ready to progress to construction. It will complement the environmental consents and other approvals required to build and operate offshore renewable energy infrastructure. The bill limits the ability for developers to land bank certain areas, or not that it's necessarily land, but or impede other developments. Permits will have use it or lose it provisions, meaning if a project fails to start or progress, the area can be made available to other developers. Feasibility permit applications will be assessed on a comparative basis and awarded to the projects that are most likely to deliver the most benefits for New Zealanders. Applicants will need to meet minimum eligibility thresholds and establish that they have the technical and financial capability to install, operate, maintain and decommission the proposed infrastructure. The Minister for Energy will consider feasibility permit applications and must have regard to any significant risk to national security or public order posed by the applicant, the impact on treaty settlements, the applicant's approach to managing existing rights and interests in the area, and the applicant's compliance record in New Zealand and internationally. Feasibility permit holders will be able to apply for commercial permits whenever they are ready to do so. The commercial permit process will provide assurance that the project is ready to progress to construction. The Minister for Energy will consider commercial permit applications and must have regard to readiness to carry out the proposed development, compliance with requirements in the legislation conditions of the applicant's feasibility permit, and the applicant's ability to put in place an acceptable financial security arrangement. It is important that people can have their say on potential developments, and there will be an opportunity to do this before the Minister for Energy decides to grant feasibility permits. Feasibility permit applications will be publicly notified, and any person who wishes to make a submission will have a reasonable opportunity to do so. Applicants for feasibility and commercial permits will be required to consult with relevant iwi and hapu ahead of submitting their applicants, and the Minister for Energy must also consult those iwi and hapu before granting any permit. Provisions in the bill relating to upholding treaty settlements and associated rights and interests will align with those in the fast-track approvals legislation, which was passed earlier today. We want to ensure that offshore renewable energy infrastructure does not become a significant financial risk to the Crown. The bill requires all permit holders and owners of related transmission infrastructure to decommission their offshore renewable energy infrastructure at the end of its life. The bill also requires financial security arrangements to be put in place and maintained to cover the cost of the Crown in the event that permit holders or infrastructure owners fail to meet their obligations to decommission. This is consistent with standard practice internationally. Other protections of the bill include the ability of safety zones to protect the infrastructure and people from intentional or accidental harm. The bill enables the administration, monitoring and enforcement of the regime and is intended the Ministry of Business, Innovations and Employment undertake this role. The bill also includes a range of offences and penalties for breaches of the regime, ranging from $3,000 to $10 million fines through to permit revocation or imprisonment for a term not exceeding 2 years. Significant fines and penalties were considered necessary in certain circumstances to provide an effective deterrent given the financial capability of likely permit holders. The bill includes regulation-making powers to set out procedural and implementation matters, such as additional matters the Minister must have regard to when determining whether to grant a permit and the provision of information. The powers include the ability to set fees and levies to recover the costs of the regulator, and I intend to progress feasibility and permit and cost recovery regulations at the same time as the bill progresses through the House. Mr Speaker, the policy proposals in this bill have been developed with input from industry and stakeholders with 2 rounds of public consultation. Ultimately, no decisions by Cabinet had been made prior to this government coming to power, and so this government has had to make those decisions, draft the legislation, and now bring this legislation to the House. I'm pleased that we've been able to do that in our first year in government, to bring this legislation to the House so we can enable an offshore renewable energy regime here in New Zealand to unlock the significant potential that exists in our oceans surrounding our country, and critically importantly, unlock that electricity which will help power our country and our economy out into the future, critically important to meeting our net zero 2050 target. The proposed regime borrows the best from more mature regimes such as in the United Kingdom, the Netherlands, Denmark and Australia, and is adapted to suit here in New Zealand. This government is committed to enabling offshore renewable energy, and it is intended for the offshore renewable energy regime to be placed by mid-2025 and the first feasibility permit application round to be opened in late 2025. I commend this bill to the House.
sounds like a somewhat sensible bill. I just hope it's not for a wind farm that may have bolted because of deep sea mining.
Yeah, so this is basically a carbon copy. It was because I did some basic reading of comparing the bills. This is just basically a carbon copy of the Crown Minerals Act 1991. It's got similar provisions, like the Crown Minerals Act also includes a use it or lose it provision when it comes to exploration permits. So they've made there's a similar clause in this bill when it comes to feasibility permits.
God, they need to sit there and put something similar into the RMA so Johnson Moore doesn't have 2 resource consent application slaps on them.
Yeah.